Hello and welcome. In the recent days, the Honorable Supreme Court has quashed the criminal case against journalist Vinod Dua. The big question raised when he was arrested: can the media be charged with sedition? Why the police have arrested Vinod Dua for such a grave charge by mere criticism of Government of India, even though there was no public disorder? We will look the wordings of Honorable Supreme Court in the journalist Vinod Dua's case. But first, let's understand what are the essential ingredients that constitutes the offense of sedition and the punishment of sedition as given in law. Sedition in itself is a comprehensive term and it embraces all those practices, whether by words, deed, or writing, which are calculated to disturb the tranquility of the state and lead ignorant person to endeavor to subvert the governments and laws of the country. Sedition has been described as disloyalty in action, and the law considers as sedition all those practices which have for their objects to excite discontent or dissatisfaction, to create public disturbance or to lead to civil war, to bring into hatred or contempt to sovereign or the government, the laws or constitutions of realm, and generally all endeavors to promote public disorder, as in Nazir Khan's case in 2003. Constitutional validity of sedition was upheld in the case of Kedarnath in 1962. The court ruled that every journalist is entitled to protection of this judgment, which said, comments, however strongly worded, expressing disapprobation of actions of the government without exciting those feelings which generates the inclination to cause public disorder by act of violence would not be penal. Necessary ingredients of seditions are first, bringing or attempting to bring into hatred or contempt or exciting or attempting to excite disaffection towards the government of India. Such an act or attempt which be done by words either spoken or written or by signs or by visible visual representation. Charge of sedition is cognizable, non-compoundable and non-bailable. Imprisonment may be extended up to 3 years or up to life and also imposed fine and is exclusively trialable by court of session. Coming back to the case of journalist Vinod Dua, the Honorable Supreme Court has quashed the case registered in Himachal Pradesh by invoking a narrowed down meaning of what constitutes the offence under section 124A of IPC. It is necessary that something I have said publicly and due to that saying there is public disorder, then only it will constitute sedition under 124 of IPC. Whereas the sayings of journalist Vinod Dua did not gather any public reaction and the necessary ingredients were not even fulfilled. Concluding all the above judgments, we can clearly see that the Honorable Supreme Court is continuously trying to bring a legitimate use of this section and no arbitrariness should be there due to this section, so that only the offender could be punished and not the person who is keeping his views forward. The court's verdict brightens the hope that the section's validity will be re examined. Thank you and have a nice day.